My name is Judge Shashi Kewalramani. I'm a mediator, arbitrator, and court-appointed neutral here at JAMS. I'm a neutral and a former federal judge. I'm also a registered patent attorney. I was a commercial litigator who handled IP and commercial cases both on the plaintiff and defense side, as well as a former federal white-collar prosecutor who handled hacking and a bunch of fraud cases. My mediation style is inquisitive and facilitative. It really evolves into evaluative because I ask a lot of questions and listen a lot. And I learn about things that sometimes isn't disclosed in the paper. Frankly, I don't know what I don't know. And those discussions allow me to learn some more information and to guide the parties to see if there's a resolution that they can get to, taking into account the risk tolerance for the litigation, as well as for the real purpose behind the litigation. In preparing for an arbitration, at the pre-hearing conference, or the earliest conference where the clients are available, it's helpful to identify particular issues for that case that are going to dictate how the case proceeds until the hearing. At the hearing, I have to give space to the parties to present their best evidence and not to make a decision until the last piece of evidence comes in. I can assist in a neutral evaluation because I've presided over thousands of cases as a former federal judge. I've seen how a variety of judges rule on issues that may seem clear-cut, but there's never anything clear-cut. And I think my insight into the judicial process, as well as being a trial lawyer who has tried cases and understand that you have to expect the unexpected. And taking all that information, I can then really converse with the clients to determine what the risks are with every approach and to give them a realistic assessment that may help them in determining what their next step should be. Trust in a mediation is paramount. It is tied up with credibility. Honesty and openness are what allows a mediator or good counsel to build a well of goodwill, which is going to have to be drawn upon at some point in the mediation when some bad news has to be given. Parties have usually been litigating a case for months, if not years, and usually the decisions have been to a third party, whether a judge or a jury has been making calls. But now, the clients and counsel together are going to be having to make that call and can move forward with either their business or their life. But getting the parties to understand that is one of the most rewarding aspects of getting a resolution done.